Tafita. Hello?
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 Yes, hello?
Hello?
Yes, Kunjani Bab. Hello? Can you unmute yourself there? Because we can't hear you. Hello? I'm struggling to hear anything. I don't know whether you can hear me or we can improve the sound here.
Mama, I can't hear, but I can hear you talking.
No, we can hear you very well.
Yes.
No, we can hear you very well.
Are we delayed? Good evening, everybody.
Good evening.
Yeah, Member Adams here. Are we delayed? Who's speaking?
Good evening,
partner.
partner.
Hey, partner.
Hi, partner.
Are we
Later.
delayed?
I don't know.
Ish.
Where's
Because
the
even the stakeholders are trying to get in. I don't know what's going on.
Where's the chairperson?
Maybe she's there by clicks, I think.
Good evening, guys. This is Mr. Mselegu. Can you hear me?
Yes, we can hear you, Mr. Mselegu.
Lwandle.
Yebo, kunjani?
Lwandle. Haluelwa. Lwelwa kunjani kuphela.
Yebo, wazithina-ke. Thank you.
Wakithi loyo mthombeni.
Ngiyabonga Mgongolozi.
Nje kutshwa.
Yeah.
He was working this morning. Do you know I'm comfortable? No, but I'm sure you're going to tell me. Wait. Aren't you nurse cohort? She'd be assistant too.
Good evening, honorable members and colleagues and all our guests. I think the chairperson, the honorable chairperson is having some connectivity issues. So she will be able to connect just now and address.
Is the meeting on, or we are still in the trial session?
We're still waiting for the chairperson to connect. Thank you.
Thank you, my honorable. Thank you very much.
As we are still waiting for the chairperson to connect, can't we have one of the pastors to preach or to give us a word of encouragement for us for so long?
Dr. Adams, pray for us.
Yes.
So if I pray now, I can pray for 1 hour. Is that okay? Diale?
You can go beyond that. You can go beyond that leadership. Take as much time as possible, as long as the
Because
chairperson is not
Good
yet
evening,
online.
colleagues.
there's so much challenges and crisis going on. It necessitates an all-night prayer in South Africa, believe me. But let us pray.
Good
Father, we
evening.
thank you for this day. We bless you. We honor you for today. We pray as we embark upon this meeting, very important stakeholders meeting with the COCTA committee, portfolio committee. We pray for our chairperson that you will give insight and wisdom, the entire committee and all our stakeholders. May your name be exalted. Father, we pray for the challenges that we face in our country. We pray, Lord, that you will allow us to be able to be united, cohesive, in unison together. Father, we will go through these difficult times. Thank you, Lord, for your blessings upon this meeting. In Jesus' name, and everybody say amen.
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 Raleboga Moruti, thank you very much. We got lost in the street of technology.
No problem, Chairperson.
Myself and other members and other stakeholders, we were in another link. Apparently, they sent 2 links. So
Yes.
apologies to South Africans and people of Gauteng. We are very sorry about that. It's technology. I guess we'll get used to it as time moves on. We profusely apologize, but thank you very much, honorable members that were in this platform, also colleagues that were in this platform for continuing with the program on our behalf. It's not in our nature to be late. We profusely apologize. We are gathered here as people of Gauteng, but also as the legislature. This is part of our public hearings on the recognition of customary marriages amendment bill. And the bill is to be amended. And this is on the basis that of a court case between Gamede. Am I audible? Yes.
You are audible,
Hello?
Chairperson. You are audible. Go ahead.
Okay, thank you very much. I'm saying we have convened this panel discussion because we thought that part of the things that we should do as a legislature in reaching out for public inputs, perhaps it's time we also, in subject like this, we call also subject experts to come and share with us. Some are activists and some are participants in customary marriages. So basically, this is part of our consultation processes that we will be embarking on in this month towards the bill amendment. And the bill really seeks to amend section 7, subsection 1 and 2. And this was necessitated because of a court verdict between Gamede and the President of the Republic. And also it seeks to eliminate gender-based discrimination that women who are in customary marriages experiences. So we are hoping to have fruitful discussions with all of you, and we are also encouraging members of the public who can participate in these sessions that will be running as the Gauteng Provincial Legislature to also log in our website, and this where you can email your inputs in writing and also participate in our stakeholder engagement that will be running throughout the month. We have invited here Ntate Matole Motshega, who is going to share with us. Matole Motshega ga tlhoke much introduction. I think a lot of us know him as one of the leaders in the country, truly, who pushes for our traditions and our culture as diverse South Africans. And we also have Mayor Shiman Samai, who is also a legal expert on the subject. We have also called in an activist, a young woman who is also in customary marriages. We also have a prince from one of the royal families within South Africa to also come share with us on this subject. So because of time, I'm not going to waste more time, but also invite Ntate Matole Motshekga to share with us. My name is Kedibone Diale. I hope some of you know me. I forgot to introduce myself. And yeah, we will continue like that. Motshekga, I'm told you are on the platform. It's now your turn to speak to people of Gauteng and South Africans, because we are live streaming on social media platforms. We are also live streaming on Mail and Guardian and other radio stations and other media platforms. Thank you very much.
Chairperson.
Honorable Member Adams.
Sorry, I think it's also will be good, because we have different stakeholders and the media, that you just introduce the members of the portfolio committee also, please, ma'am. Before Ntate Motshekga starts, please.
Thank you very much, Honorable Dalton. My apologies. Like I said, I had started the session in the other platform, so I'm sorry. Let me perhaps give platform to honorable members. With me here, we have maybe perhaps honorable members. Let's start with all of you, just to introduce you, greet and say your name only.
Honorable Bishop Dalton Adams, a member of this portfolio committee. Good evening, everybody.
Share your face, and Tate Dalton. That's how he looks. Thank you very much. Member Msimang.
Thank you very much, Chairperson. Member Solim Simanga of the COCTA portfolio. Good evening to the stakeholders and to the people of South Africa.
Thank you very much. Member Doss, I know we were lost. Okay, you're here, okay.
Thank you, Chair. Evening, everyone. Member Sergio Issa dos Santos.
Thank you very much, Member Doss. Member Ncube.
Good evening, everyone. My name is Khomotso Tong. I'm a member of Committee of Human Settlement and Co-operative. Thank you.
Thank you very much, Member Khomotso Tong. Member Greg.
Good evening, Chairperson, and good evening to all the stakeholders that have joined us tonight and those who are watching on other platforms. My name is Greg Schneeman, and I'm a member of this portfolio committee. Thanks very much.
Thank you very much. If you're not an honorable member, please switch off your camera. You will have a turn to switch it on. Which other honorable member is here that I've not noted?
Sirota, Chair.
Oh, Ntate Sirota, please come in. Show your face so that South Africa can see you.
Good evening, everyone. Welcome. I'm a member of this committee. Good evening. I hope we have a good meeting. Thank you, Chair.
Thank you very much. Member Malema. We have
Member Magagula is here.
Member Toko Magagula, the Deputy Chief Whip, come in.
Thank you, Chair. Thank you, Chair. My name is Tobozile Makakula. I'm not the member of the committee, but I'm the member of the provincial legislature. Thank you.
Yeah.
Thank you very much.
Chair.
Yes.
Chair.
Who's there?
I'm wondering what is it, Marcella?
Can I come in, Chair?
Oh, Madam Speaker. Okay. Can I first have Member Lidwaba?
Good evening, Chair. Good evening, everyone. My name is Marcella. I'm a member of the portfolio committee. Thank you, Chair.
Thank you very much. outside the Speaker of the Gauteng Legislature, do we have any other member? Okay. Honorable
Yes,
Lindsay.
Chair, I'm here.
Okay. Who's here?
The former member of the committee.
Oh, MEC Social Development, you are welcome. Thank you very much for coming.
I still miss this committee.
Okay, thank you very much. I'm now going to hand over to Speaker of the Gauteng Provincial Legislature to introduce herself and also introduce Ntate Mathole Motshekga on the behalf of the Gauteng Provincial Legislature.
Thank you, Chair. Thank you, members. I'm here not as a speaker, but as an executive member of the Multi-Party Women's Caucus. As the Multi-Party Women's Caucus at the legislature, we have an interest in this particular matter. Hence, we will be listening, but also making our inputs when it is needed. Let me take this opportunity to also introduce Honorable Motshekga, our advocate and our leader, who is also the former Premier of the Gauteng Provincial Legislature, but also we know him in various platforms. In the interest of time, I will request members just to Google our leader. I don't want to take longer because already we ate on our time. 35 minutes is gone already. So you're welcome, Dr. Mathole, as our leader. Thank you very much for coming to give advice to this honorable platform. Thank you very much.
Thank you, Madam Speaker. Ntate Motshekga.
Platform. Is it my time to make an input? Let me start off by saying that the challenge that we have is that our constitution gives English common law, Roman Dutch law, and indigenous African law called customary law equal status. But in practice, the three systems of law are not given equal status, but also the literature that is used when we deal with African customary law is written largely by people who don't have personal knowledge of that system. And they also don't depart from the premise that African marriages are first and foremost based on African spirituality and cultures. It's not simply an agreement between two individuals. The two individuals decide to marry, but the two individuals have got to bring the two families together, and the two families have got to bring the ancestral families together. So African marriages are very, very complex. Now, when one reads the customary law bills, it doesn't seem to be informed by African jurisprudence. It is rather just a recognition of the coming together of individuals. And that's why we have been calling for the introduction of customary law as a compulsory subject at our universities, because our professors of law, our magistrates, our judges are not educated, learned in African spirituality, African customs, and as a result, they simply try to utilize concepts and principles which are borrowed from foreign systems of law. So this is the difficulty that we are facing. Also, we find that people recognize the cultural diversity of our people, but this cultural diversity does not actually affect the philosophical underpinnings of these marriages. So I think that our starting point, if we want to have customary marriages that are truly African marriages, we have to go into the philosophy underpinning these marriages. For instance, you find that two parties will enter into a customary marriage, but end up upgrading that by signing before a magistrate. And now, if it has to be a dissolution of the marriage, you find that the people talk about umfaziwe pep. The signature before the magistrate prevails over the indigenous processes that took place. So I am just wondering whether we are really ready to address this matter as matters stands now, and whether sufficient consultation with the elders has taken place. And unfortunately, hello?
We can hear you, Ndati.
And unfortunately, we had a load shedding. I could not access the text so that I'm able to talk to the formulations of the text. Maybe with your permission, I could come back if someone has dealt with the text, so that I have an idea as to what are the critical issues that are being raised in the bill itself.
Okay, thank you very much, Ramoteka. Just for housekeeping issues, in all our platforms, if you have your questions, please note them, and those who are on Facebook, please read them. Our media team is monitoring, including YouTube, and those who are on this platform, you'll also write on the chat group, or you'll raise your hand when time comes. You'll have all the presenters presenting, and then give you an opportunity to ask questions and also make your inputs. May I request Advocate Shiman Samai to come in? Prof is saying will come later. Perhaps maybe you will be the last one to speak, Prof. Is it okay with you? Ramosega. Is it fine that you come last? Okay. You are still muted, but I can see you are agreeing. Ms. Shiman?
Yes, thank you very much, Chair. I'm Shiham Samai. I'm from the Women's Legal Center. And I also have one of my colleagues is also here, which is Lulama Shongwe. And she made the submissions to the National Parliament and drafted the submissions in relation to the amendments to the Recognition of Customary Marriages Act. And I think it's important just for us to be able to go through in terms of the legislative changes that has been always going to be affected during this particular process. And I think everybody should know why. Firstly, through the chair, I just want to note that in a diverse society like South Africa, we all know that there are many forms of relationships between people entered into in terms of civil marriages, customary marriages, same-sex marriages, as well as domestic partnership. And we also have religious marriages. But while, as Professor Moseka has indicated, while that all of these post-1994, the South African Constitution entrenched progressive rights for women through the Recognition of Customary Marriages Act, and prohibited various forms of discrimination based on sex and gender and religion. We all know that the actual implementation of the Recognition of Customary Marriages Act has been a major challenge, which is one of the reasons why the Women's Legal Center have approached the court 10 years ago in terms of Kumedi, and also up until recently, which is the Ramahovi case. But before I get to that, while civil marriages are always recognized and fully protected by our law, this, as we note, as Professor Moseka has indicated, is not true for all relationship in terms of implementation. So although the Constitution recognizes customary and religious law and restrict laws violating the rights of women, we all know that there remains major challenges. And the vast majority of Black women in South Africa are in relationships that either have no legal protection or there is problems in relation to actual implementation. And so the non-recognition and the non-protection and lack of enforcement leads to economic hardships for women, and it perpetuates discriminatory practices and abuse of women. The live reality of this is that the rights of thousands of women remain severely restricted, and children born of these marriages. So since 1999, the Women's Legal Center, which is a feminist legal center and advances the rights of women through strategic litigation, brought various cases to advance gender equality. And the Women's Legal Center, since its inception, has taken up cases of women to ensure that women receive a fair share of assets of the partnership and after the dissolution of that particular partnership. So briefly, I mean, I'm not going to speak much longer because I think it's important that we actually look at the actual amendments and why even in terms of the Gauteng legislature should support same and on what basis should those amendments be supported. But the Recognition of Customary Marriages Act, as I've indicated, had its shortcomings after it was enacted. And in the case of Kumedi versus President of South Africa and others, it ruled that women married in monogamous customary marriages before the implementation of the Act are covered by the provision. So it declared that particular provision unconstitutional to the extent that it did not protect women married in terms of customary marriages, but only in a monogamous relationship. Subsequently, this particular legal issue was brought before the Limpopo High Court, and in Ramahovi and others, the issue of polygynous marriages was addressed, and the Women Legal Center submitted in that particular case that women in polygamous marriages should have equal rights in and control over their marital property of their husbands and other wives with respect to the house property. These rights are to be held and exercised jointly by the husband and wife concerned and with respect to the estate property. The rights should also be held and exercised jointly. The court at that point in Limpopo declared provision section 7.1 of the of the act as inconsistent with the Constitution and also invalid. So we know that subsequently what happened was that for those that wanted to know what happened in that particular case, the children of the deceased have made an application to court to challenge their right to inherit the deceased father's estate. And the applicant's parents were married before the Recognition Act, and in terms of which the polygamous marriage was considered to be governed by customary law only, and therefore the wives did not have any right to the husband's property. And the court, at the end of the day, the premise of our submissions to the court was that for better protection and also in order to ensure that any practical problem arising may be addressed properly, it could be and consistently, and that there is equality between spouses. And I think that the Women's Legal Center, the matter then went to the Constitutional Court for confirmation. And the Women's Legal Center at that point in time with Legal Resource Center was the amicus curiae, or the friend of the court in that particular case. And the court, the Constitutional Court, declared that that particular section of the Recognition of Customary Marriages Act was also unconstitutional, and it gave the state 24 months to remedy the rights violation. And then this had to happen by the 30th of November 2019. It's further noted that did, and sadly what happened was that by that particular deadline, it wasn't remedied. And the deadline, there was an application that was made back to the Constitutional Court, but the court at that point indicated that the deadline has passed and that it needs to be remedied. No further extensions would be provided. I'm going to leave it as that. I know that it's about 5 or 6 minutes. I think it's exceptionally important that my colleague Lulama actually just come in and to be able to speak directly to why the amendments are so important, as it seeks to remedy the discrimination against women who were precluded from owning or holding rights in property and management, as well as controlling property equally with their husband. But the underlying explanation will now be provided quickly, Chair, by Lulama. Lulama.
Good evening, everyone. Sorry, I came into the meeting a little bit late, so I'm not too sure what else has been covered by the other speakers, but I just want to maybe just nitpick a little bit from the submissions that we had made in writing as well as orally to Parliament on these specific amendments to the recognition of the Customary Marriages Bill. So this amendment is of particular importance to a very specific category of women, and these are women who have been affected for many years by the lack of protection afforded to other women who could have their marriages and rights in marriages recognized through the Recognition of Customary Marriages Act. In our experience, these are older women who live in both rural and urban areas according to their custom, and who seek to give effect to their constitutional rights to do so. And so for them, the importance of this amendment cannot be overstated as it seeks to remedy the discrimination against women who were precluded from owning or holding rights in property and managing or controlling property equally with their husbands, and specifically in polygamous marriages with their husbands and other wives. So we are obviously in support, as Siham had mentioned, in support of the proposed amendments in the bill as they seek to give effect to the remarks made in Ramobi that the state and Parliament is actually enjoined by the foundational values of the Constitution, and thus they have to amend the law to create a default position that allows for the rights of women in pre-act polygamous customary marriages to prevail. And so in doing so, the legislature would be able to remedy a situation that previously discriminated against these women on the basis of their gender and marital status, which obviously resulted in an infringement of their right to dignity. I don't want to read everything from our submissions, but I do want to speak about specific sections of the bill and why we're in support of them. So first of all, we had noted the inclusion of an amendment to Section 7, Subsection 2 of the Recognition of Customary Marriages Act in the current bill, and we welcome this inclusion, which is something that we had recommended to the Department of Justice during their consultation process. This amendment was prompted by the judgment in Gumede that Siham had already mentioned. Gumede found that this section of the Recognition of Customary Marriages Act was unconstitutional, but no amendment was ever effected by the relevant department. And so 10 years later, since the judgment in Gumede, we now have the judgment in Ramuovi. And so one of the issues we raised is the issue of defining what is meant by marital property, house property, family property, and personal property in the proposed Section 7(1)(d). In our experience, the very reason for sort of contestations and having to go to court over these issues is disputes within families relating directly to assets which are accumulated by the parties during the subsistence of the marriage. So we recognize and acknowledge the role of custom when it comes to how property may be acquired, owned, and shared in the family context. But we're also mindful of the fact that the Constitutional Court has repeatedly pointed out and confirmed that some customary laws as well as practices are steeped in patriarchy and patriarchal principles. So there is quite a strong concern that patriarchal stereotypes will feed into the manner in which marital property, house property, family property, as well as personal property will be defined and practiced within custom. And so we have a unique opportunity now to establish and define those terms, considering the constitutional dispensation that we find ourselves in at this current time. The Department of Justice then got back to us, and they did note some concerns during their public participation process that defining these terms may alter or change the actual custom which exists. And sure, I mean, this is a very good point that was raised, but we also have to recognize that the Constitutional Court has expressly confirmed the living nature of customary law. And so we can't think of it as something that's stagnant or something that's not movable or adaptable to the times that we are living in right now. Just skipping forward. Yeah. So yeah, on implementation, the courts in Gumede and Mailani have recognized that there was a need to educate people who practice any custom that there have been normative developments made to their rights. And so we can find no indication that the relevant government department ever embarked on an education drive after the Gumede case and also Mailani, to educate people on the impact that these judgments have on their lives. And for us, that's a critically important aspect of the whole process. Because, I mean, we have to bear in mind that in the absence of financial and other resources and within limited access to justice, the class of vulnerable women to whom this amendment speaks will continue to not reap the benefits of the change if they know nothing about the fact that normative changes have been made to their rights in terms of different judgments that the Constitutional Court hands down. And so just those are some of the bigger issues and types of things that we spoke about when we made our submissions in support for the amendment to the Act, and especially in terms of this particular bill. Thank you.
Thank you very much, Lulama and Shiman, for your insightful inputs in this discussion. I'm going to now request Commissioner Busisiwe Day from the Commission of Gender Equality to also come in and make her input. And I think all of you are recognized. I see some of our former leaders in Gauteng have joined in, and the HOD from COGTA is also here. You are all welcomed, colleagues. Commissioner Busi? Is Commissioner here? While waiting for her, can we have advocate coming in?
Thank you very much, Chair.
Is that Advocate Sima?
Yes.
Okay, yeah, come in.
Thank you very much, Chair, and good evening to everyone, and thank you for the invitation. My name is Advocate Matumi Sima. I'm a practicing advocate with my rooms at BJ Chambers in Johannesburg. I would like to make a submission to this committee. As a point of departure, one should acknowledge that the amendment of the recognition of customary marriages is long overdue because the most affected people affected by this legislation are the poorest of the poor, the downtrodden, and women in particular. In this sense, practically, you would have our courts being the court role being clogged by matters of this nature, wherein women who are involved in customary marriages are constantly having to go before our courts to enforce their rights. But if our law is not clear around the whole question of inheritance in the event that a deceased dies interstate living spouses, because before our law, the spouses to a customary marriages before the eyes of the law are recognized as spouses. In other words, there is no dichotomy between the two, and if a deceased dies leaving them before the eyes of the law, they are recognized as spouses. So now we need a situation where in the legislature in amending this law, it becomes very clear around the division of the estate, because previously we would have a situation where in one spouse is preferred over the other, or another spouse would decide to be having to share with the children. So we want a situation where in all the spouses, one, by virtue of their recognition as spouses as a result of operation of law, are actually recognized in such a way that they are able to inherit equally on the estate. Because the Interstate Succession Act of 81 of 1987 does actually, in its amended form now, recognize the fact that post 94 we had the Recognition of Customary Marriages Act, but now the recognition of Customary Marriages Act in itself has been insufficient to an extent that we had the decisions that were mentioned earlier, which I cannot repeat. But now, as a practical solution, honorable members, as the legislature, we need to come up with a clear distinction of, with these spouses having been so defined in a polygamous marriage, how do they then, in the event of a disease dying interstate, how do they then actually share equally on the estate without them having to go to the courts and clog up the court roll with matters that could have been made clearer by the law. And in my conclusion, I wish to state the following: that customary law, as is being said, it is a living law. It needs to be developed in such a way that more people should play a role. What I mean is that the legislature should actually go to the communities, the communities wherein this particular law is being practiced. For instance, our community, rural communities and township communities, wherein the people who are actually being affected by this law are actually residing. And they're the ones who must also, amongst other things, be the ones who must be making submissions. We are making submissions on their behalf. On that is that we recognize the fact that there have been historical injustices, and as a result, we welcome the amendment, and of the view that to also take into account the fact that spouses in this kind of marriages are also being taken into account and being given a fair in this regard. Thank you very much, Chair.
Ralebuga Ntate Sima. Commissioner Busi, are you here? Okay. Musima Kekana, please follow up with Commissioner and check where is she. I'm now going to give an opportunity to Prince Jeffrey Rathagani. Is Prince here? Is the Prince here?
Hello, can you hear me? I'm here.
Yeah, we can hear you.
Thank you, Chair. Good evening, ladies and gentlemen.
Just show your face so that we... Can you show us your face?
Just one.
Yeah.
Can you see me?
Yes, we can see your beautiful face. Thank you very much. Continue.
How are you? Thanks for invitation, Chair and the colleagues. I'm going to speak from the experimental background of this bill and also regarding the customary marriages. The experiment being in this way, I'm from a royal family. Can you hear me? Hello, can you hear me, guys? All right, yes. Now I'm going to talk from that background regarding customary marriages. Now, from my experience is that the chief or a hoshi will have more than one wife. And normally in our tradition, we don't call them wives. We say it's called more than one houses. So now when coming to succession, each and every house will own their share. Can you hear me?
Yes, please don't stop until we say we can't hear you. So you can continue.
Okay.
As long as we don't say to you, we can't hear you.
Yes, I'm saying now, when coming to succession and or inheritance, for example, if a house has about 3 wives, now each and every household will claim their inheritance from that house. Their wife and their children, for example, of the first house, will be entitled to the property of the first house. And the wife and children of the second house will be entitled to the property of the second house. So now, my experience is that there have never been any dispute regarding the inheritance and or succession, because you are going to inherit what your house has. But now, if the father, being the chief, passed away, Then now all of the family, they're going to share what belongs to the father. You get your share as a family. If you have for example, 10 cows in your house, then you'll be entitled to claim those 10 cows or cattle, and plus what belongs to the father. Because what is in your house is in your house. The second wife or the third wife cannot come and claim what belongs to the first wife. And it will be unfair to expect children from the first wife to come and claim what is due to the third wife. So we have never experienced any problem. I grew up from that because my grandfather had about 4 wives. We have never experienced any problem, and we know each other. We know that this property belongs to that family and this one belongs to this family. So we have never experienced any problems. Yes, I agree with the amendment. And it will be unfair to expect doing it in our children from the first wife to come and claim the ownership and the rights of the third house belong to that house. There's no way that another wife can come and claim the inheritance of another house. So we have been doing that in our family. We've grown from that, having an experience with that. We have never experienced any problems. Yes, sometimes people will come to the crawl where the husband had about more than 1 wife, and then now the uncles will come and claim the property of their brother because they will regard the wife as a child. Then we have resolved that most of the time to say, no, what belongs to the wife, it belongs to the wife. This is experience that I've learned from the background of the Marital Traditional Council. The Bedis, we have been doing that. Yes, other tribes, they will say, if you pass away, then the woman is being treated like a child. You don't have to own anything. You don't even own a land. But from my background, we can even issue a stand to a female. We don't discriminate between a male and a female. It has been done that my grandfather has been doing that, even my father has been doing that. We are doing that even today. There are instances where a female will come, he doesn't have a husband, he's not married, but he has got a child. They will come, will offer him the residential plot. That property belongs to her. There is no one or a male who can come and say, no, because you are a female, you are not entitled to claim. They are entitled to claim from our tribe. But yes, I agree with the amendment because previously some other tribes, the female will be subjected to discrimination. I've also dealt with matters from the Royal Crawlway, especially regarding the Zulus and the Tongas, because we have multiple cultures in our village, where they'll say, no, a female cannot own a property, but from our tribe, you own a property and you can inherit that, whether you die intestate or die testate. If you die intestate, your children can inherit that. If the husband also passed away intestate, the wife will inherit that. And then if there's no surviving spouse, then the property will go to the children. We have never discriminated against women and or children. But yes, I support the amendment because I have experienced where many females have been subjected to this kind of discrimination. And I've also been to court several times where we'll represent women to fight for their rights. I thank you, Chair.
Thank you very much, Ntate Ratlhagane wa Bokgosing. Commissioner Day, are you here? I saw you coming in, and our apologies. I think the mistake of sending 2 links confused a whole lot of people. Can one of the officials go to the other link and fetch people from there? Because I think there's complaint that there's people in the other link. Commissioner Day, are you here?
Yes, I am here. Can you hear me?
Yes, just show yourself.
Okay. Is my camera working on your side? There we go. Sorry about the bright light on here. I can't move it. It's my desk light here. I'll try and move a bit like this. Is that better?
Yes, I can see you. Or is it because I know you, but I can see you?
It's just my light is a bit bright to give, my face some definition as well.
Okay. Thank you. You can continue.
I might be repeating some of the issues that I highlight in my contribution. Firstly, good evening to all honorable members. Good evening to all guests who are part of this panel discussion. Thank you very much for giving the Commission for Gender Equality the time and the platform to make submissions with regards to the amendment of Section 7 in the Recognition of Customary Marriages Amendment Bill. I do want to begin by introducing the Commission for Gender Equality. It is a Chapter 9 institution. It has powers to investigate and make contributions in relation to gender inequality and gender discrimination. And so we come as a Chapter 9 institution that is tasked and mandated with ensuring that South Africa moves towards being a society that is that undoes, the past in terms of gender inequality, but also moves towards a future that is based on gender equality. And I do want to begin by stating that we as the Gender Commission, or the Gender Commission, is in support of the amendment, but I do want to bring a bit of context to our submission. I do want to make sure that we understand that we are moving from the value and principle of equality and human dignity, which is a central value that is contained within the Constitution. And so the decisions that have been mentioned, I have been listening via your YouTube streaming site. The cases that have been mentioned, Gumede and Mayelane, I dealt briefly with Mayelane when I was a clerk at the Constitutional Court. They are based fundamentally on a recognition of the historical, structural, and systemic inequalities that were enacted against particularly Black women. We have to understand what the Recognition of Customaries Act did. What it did is it's part of a history of legislative enactments that were meant to disenfranchise and dispossess Black women, Black rural women in particular. So we begin in the 1800s with the Glan-Grey Act, which created the principle of male primogeniture, which created the legal principle, and entrenched the legal principle that Black homesteads were entitled to only 4 I think it's Aragon of land, which is very small. And also they created an inheritance system of male primogeniture that within each homestead, Black homestead, the inheritance would move from the male head to the male child, the firstborn male child. Now, the assumption is that this is within the historical tradition of Black people. But this is entirely not true, but it's a Western and European and colonial imposition on our cultures and customs. I heard one honorable speaker mentioning that in the petty culture, actually, there is a way of distributing equitably matrimonial property. And so that is what is lost in conversations such as this, is that oftentimes we take colonially imposed, for lack of a better word, traditions and make them part of Black indigenous culture and tradition. So what this section is undoing is 400, 300 years of legally enforced inequality that was meant to structurally and systemically disenfranchise and dispossess Black rural women. And the main principle and the central principle that must guide this amendment is the principle of equality of contribution in creating matrimonial property and creating the matrimonial home, but also when women leave a marriage or when they are left in marriage. Oftentimes, that is their most vulnerable moment because of this history of legislative dispossession and marginalization. So as the Commission for Gender Equality, noting this history of Black women being historically through laws and through colonialisms and through apartheid, being disenfranchised and dispossessed of their land and of their contributions to the matrimonial property space, what these sections are seeking to do is bring back the dignity and a level of equality for Black women. So what is important for this, for the Commission for Gender Equality is the recognition that this section gives of the equal contribution of Black women to the matrimonial home and to creating matrimonial property. You will note and you will remember, honorable members, that Gumede, the versus the President of South Africa, you will note that what brought about this issue was that Mrs. Gumede was put in a position of vulnerability. In that, her marriage would be automatically out of community of property. That meant that all her 40-odd years of contributing to creating and contributing towards the homes, the two homes that they bought together with Mr. Gumede, she would not have the legal right to a share to those homes. So this is about fundamentally the right to equality in ownership and equal share of matrimonial property. However, we do want to make and point to some issues regarding this amendment. The issue of registration. Although we support the Section 7 and the amendment that ensures that the right to equality and the right to dignity of Black women is restored in its rightful place according to our Black indigenous traditions. Oftentimes, the conversations that we have forget that Black women have occupied a very important and primary position in determining how property is distributed, who contributes to the creation and maintenance of matrimonial property. And so what is being brought is we are being brought closer to our Black indigenous cultures. But we do want to note that there will be, the Recognition of Customary Marriages Act is the amendment of Section 7, 1 and 2 of the Recognition of Customary Marriages Act does not do away with some of the other issues that still perpetuate the inequality that is embedded within the customary marriages legislation. For instance, if you look at Section 4, which requires that within 3 months that the second marriage must be registered, what happens is that when women do go and register their marriages at Home Affairs usually rejects their application because Home Affairs has noted, in our experience, this is from our experiences, this is from the complainants that have come to us as the CGE, and oftentimes what the Department of Home Affairs says is that they do not want to register a marriage that will then be disputed. And so the position of vulnerability of women, particularly second and third wives, is maintained. So I do want to note and bring our attention to Section 4.1, which still puts the imbalance of power in favor of men. So if a man does not want to register this marriage, automatically the second marriage, not the first marriage, but the second marriage, falls in, becomes and is regulated as a marriage out of community of property. And what we would suggest as the CGE is a clear directive within the section that notes and directs the Department of Home Affairs that where an application for the recognition of a customary marriage, particularly a second marriage, that the Department of Home Affairs is mandated to register such a marriage, or where an alternative, if the Department of Affairs fails to register such a marriage, then there are alternative mechanisms of registrations that are provided for women. Because what is continuing, and what we've seen with the Recognition of Customary Marriages Act, is that it continues to place Black women particularly in a position of vulnerability. This is not an error, but it's part of the structure of colonial and apartheid disenfranchisement of Black women, particularly by taking away the full recognition that Black women deserve in the contributions that they have made in creating the matrimonial property home. But we do know, and this is my concluding remark in relation to this, we do know that maintaining this position of vulnerability, particularly in relation to Black women, is part of overall disenfranchising Black Indigenous communities. Who is bringing in, who is the inheritor of, family traditions? Currently in our society, those are women. We are a majority single mother-headed household in South Africa. And so these policies and these ways of thinking and disenfranchising Black women and considering Black women in a position of perpetual minorhood are part and parcel of the colonial and apartheid projects. And we have to link these. The gender inequality and gender discrimination continues the history of marginalizing and dispossessing Black communities as a whole. If we look at who is the guardian of language, who is the guardian of culture, who is the guardian of tradition, these are Black mothers, these are Black women, and central to disenfranchising the Black communities and Black Indigenous communities in particular. Part of the colonial and apartheid project was ensuring that Black women do not get equal share of the matrimonial property, which means that Black women are not able to provide for their children, provide for their communities. So I will stop there. Those are the contributions made by the Commission for Gender Equality, and I welcome engagement on our contribution, and I hope that this will enrich the conversation in relation to the Section 7 amendment of the Recognition of Customary Marriages Amendment Bill. Thank you.
Thank you very much, Commissioner Day. Ka Setswana sa gaetsho ra re o buile go tlala seatla. Is Mokgadi here?
I am here, Chair. However, I'm just having a little bit of problem. I'm not sure if you can be able to see me. I'm having a problem with some light here. Is it fine if I speak through the audio?
It's fine, but it was going to be beautiful if we see your face, but it's okay, you can continue.
Okay, let me just try a bit.
Please.
If you are not recognized to speak, please switch off your mic.
Can you see me now, Chair?
We can see your beautiful face. May continue. Thank you very much.
Okay, good evening and good evening to all the honorable members. My name is Mokgadi Nakana. I will be speaking basically from a statewide point of view. I would say
The current bill.
Mokgadi,
is
we lost your introduction. Remember, we could not introduce you because we're rushing time. Please introduce yourself.
Okay. I am
Who
Mokgadi
is
Nakana.
MP? Sorry, Mokgadi. Mandla, Pete, please switch off your mic. Thank you. Switch off mic. Thank you. Mandla, continue, Mokgadi.
Okay, I am Mokgadi Nakana. I currently work for the GPL. However, I am not here at that space. I found this topic to be very interesting because I am one in a prospective polygamous marriage. I could say that I am in support of the new amendment bill, coming from a point of view of saying that as a modern woman, although that I will be venturing in a polygamous marriage, I am, however, interested in knowing how am I going to be protected as a first wife or as another spouse in another marriage, because I believe that it won't be fair if I get to start to work now and accumulate assets, and at the end of the day I get to a point where my kids will not be able to be in a space where they can inherit such assets that I would have worked hard for. So I would say that the current bill doesn't only affect those who have entered into the marriage before, but however, even us who are also willing to be in that kind of a setup. We need such laws to guide us in terms of knowing that the kind of a marriage that I will be entering into is not going to disadvantage me as a woman in the end, because we may say polygamy is good, polygamy is right. However, you never know of the kind of challenges that you may meet in future. So I would say that I could say that a lot of people have already said a mouthful, based on what I would say that the current bill doesn't necessarily cover, or it doesn't necessarily protect the rights of the spouses that are found in polygamous marriages. So I would say that as a first wife, in a point of view, I would say that we are in support of the new amendment bill, and we are also saying that we are in a space where we want to engage further to hear more about our rights, because currently there isn't so much of information that is that we know of. You just know that you enter into a marriage. You don't get to know of the disadvantages thereof, how, especially for a person who's working like myself. You have already started to accumulate some assets, and now you don't know how, when you enter into such a marriage, what is going to happen. So I would say that I'm not going to be so long, because a lot of points that I wanted to cover have already been covered by the previous speakers. Thank you.
Thank you very much, Mokgadi, for sharing your experiences with us. And I think you are representing a whole lot of women out there who cannot, who don't know the process and who cannot speak. But we will try hard as Gauteng Provincial Legislature to reach out to all women, and we request everybody that has access to us now to share the light with many that we cannot reach, but we are trying our best to reach almost everyone in our province. I'm told that Musa Mseleku is here. He also wants to make an input. And I'm going to then, after Musa, Professor Motega, you will come in. Baba Musa Mseleku. I see also Solim Kize, your hand is up. You are noted, not yet recognized. Is Mseleku here? Okay, let me go back to Prof. You want to make your input now, or should I take questions? Because I think some of the questions here might need your intervention. What are you comfortable with? Switch on your mic, Prof. Your mic is off. I see you are talking, but we can't hear you. Where is that little one that was there with you earlier? Okay, let's wait for him or her to come and assist you. Let me take Soli. I saw your hand is up while we're waiting for Prof to connect. I'm not sure if he can hear me. Okay, I
Prof,
see it's like.
Thank you very much.
Fano team, can you
Can you see me? Solim Kiza.
Yes, Solim Kiza, I can see you. I'm just trying to communicate. Team, please check with Prof. Tell him we can't hear him. I see he's trying to seek help. Let's continue. Solim Kiza, you can come in. I hope Prof can hear us.
Okay. Yeah. You know, mine are more of concerns to the bill, especially the bill to say, where does it invest its powers? One, here is the scenario that I want to paint. Most of these marriages they are marriages whereby you will find the husband from a rural area will marry a woman through African way. He moves to urban area. He doesn't tell the woman at home that I'm taking another wife. Now, my concern is the legality of the second marriage. If we say all these English, Dutch, Roman law are equal to African law, it will mean that the second marriage in the urban area without the consent of the wife at the rural area will be null and void because the laws are equal. One. Now, secondly, will be the issue of estate. The issue of estate, it can never be equal because even the time it's not the same. It can rather be equitable share of estate. It can never be equal. Why? Because the first wife, in between the first marriage and the second marriage, the accrual of assets in that time, all of those assets belongs to the first wife. Then when the second one comes, the accrual of assets at that time, all of those assets can be shared equally. So my concerns are around that area to say, now when we speak of which one should the law recognize? The first one or the one of home affairs? And if the first one was customary, then it will mean without a consent of the first wife, the second one, it's null and void. But also the process for the first one to be recognized, it is a long process, number one. For someone who lives in an area where there are no resources, like anyone who's in the urban area, it also becomes unfair to that first wife. If the first wife is in the rural area, must apply to the courts, must prove, and you can only find that the first wife is been in that marriage longer than anyone else. Now, the issue of documentation.
Sorry about that, but continue, Ntate.
I am available now. Can you hear me?
We can hear you, Prof.
I can come in after him.
Okay.
Can I
Are
proceed?
you not? I think he's done because his mic is muted.
Can I proceed?
Yeah, I want you to proceed, but I wanted to take Musam Sedeku before you come in.
Okay, fine.
Is it okay?
It's okay.
All right. We are going to pardon you, Prof, because I see the function of switching off the mic and on. It's a problem. Tatem Sedeku, is he here? Where is Museleku? I'm giving him the last chance
Yes,
now.
I'm here. I'm here.
Okay.
Chair. Oh, thank you so much, Chair. I am going to be very brief with my contribution. First, thank you so much for inviting me, and greetings to honorable members. Mine is going to be based on the experience and the life that I'm living, because I'm a polygamist myself. But I must say, most people, is that most people have been trapped in both the civil and the customary marriage at the same time, especially men who seek to lead the polygamous lifestyle, due to the fact that there's been a lack of education as far as the marriage itself is concerned. What's happening, or what I've been thinking and observing, is that most men will marry in a civil marriage and then later realize that they want to take the other second wife. And it becomes a challenge for them when they want to take the second wife, because they would have been already married with the civil marriage. And that in its own makes it difficult for them to be able to dissolve the other marriage so that they can have a customary marriage. I think that is one of the big problems that most men are facing in South Africa. And that, when it happens, the first wife sometimes becomes reluctant to allow the man to dissolve the marriage in order to accommodate the second marriage. And then that will prevent the second wife or the third wife to be recognized legally as a married wife. I think we need to do something around that as well. As far as polygamy is concerned, I think in its nature, it's about equality. But it happens that because of the lack of education, especially to men who want to lead this kind of a lifestyle, they will always do things that discriminate the very same women that they say they love. That is the biggest challenge that most women find themselves in. Sometimes it happens vice versa, where a man will take a second wife because he has got other intentions or motives of punishing the first wife. And that will then make this man, when it comes to inheritance, to make unfair decisions that automatically are going to exclude the first or the second wife. So mine, from where I'm sitting, I think I welcome the amendment, but I would emphasize the point that was raised by most of the speakers, that we need to embark in an educational process. Because even if we can have a bill, but without educating the very same people who are saying they want to practice this kind of marriages, we would not succeed. First, we will make these women to be subjected in the process where they have courts. And sometimes most of them, they don't have means and resources to take whatever matter to court. So I can simply say, people who are practicing this like us, who are also researchers, who are also writers, they need to do more work together with government in terms of advancing the cause of educating the people that want to practice this. Thank you so much, Chair. I think that would be what I would want to put forth for now.
Siyabonga Baba, thank you very much. Prof, over to you now.
Yes, I think the confusion that we have is created by the government itself. Firstly, a traditional court system is an interconnected, interrelated, and integrated system. The court of first instance is the family court, where the families have to resolve the dispute, if any. And in my view, and in agreement with the man who said he came from the Matala family, there shouldn't even be a dispute. Because if you marry a woman, it becomes a household or a unit. The second one becomes a household or a unit. So each household or unit is entitled to what belongs to that unit. So you don't inherit across units. And even if that woman doesn't have children, you can't disinherit her because she has become part of that family. But if the family cannot resolve the matter, you escalate it to the village court. If it can be resolved there, it must be escalated to the chiefs of chieftainess court. If it can be resolved there, it goes to the king or queen's court. But this situation where before the exhaustion of the traditional court system, allowing people to go to magistrate courts, going to high courts, going to constitutional courts, which are not competent to deal with these issues, because these judges, these magistrates have not been educated in the system. So the long and short of it is that they are not competent. The courts themselves are not competent to deal with the issues. But also with regard to nomenclature, why should we as African people on an African continent talk about black marriages? Because the term black includes colored and Indians. And Indians have their own system informed by Muslim law or Hindu law. So when we say black, who are we referring to? And also the question of intestate succession does not even apply, because if a man dies and he has 5 women, wives, each household will keep what they have, and no first wife or last wife will get into the second wife or first wife to try to get any assets from there. So all this confusion arises because we bring Western concepts into an African system. So the question of contribution does not even arise as well, because the woman, as someone said, is the custodian of the values. She brings up children. Her contribution is that of building the family. So what the husband has brought into her household cannot be a matter of discussion on the basis that she has not contributed. She has contributed by virtue of having been part of that household. So I think that the principle of equality between husband and wife in a particular household should apply unqualified. And this question of registration, I don't think whether the marriage is registered or not, as long as there's evidence that this woman has been married to that man, and the families and the communities can testify to that, actually registration should be immaterial in this case. And this so-called normative development, the people who develop the normative system themselves are not educated on the system. Now, how do you develop the norms to govern a system that you don't even understand, that you are not even learned in? I think something that one must also say is that this thing of creating houses of traditional leader, district houses of traditional leaders, provincial houses, national houses, and therefore creating a social distance between the traditional leaders and their communities. We create a situation where traditional leaders, some of them don't even understand the system governing their people. A traditional leader must be a specialist in the customary laws of his people. And the time that they spend being ex officio councillors, being in the district houses, provincial houses, national houses, is adding to the problem. And I know there's the Justice College. And in the Justice College, with due respect to my colleagues there, you send judges to go and teach traditional leaders customary law. And their point of departure is that of teaching human rights. And African jurisprudence is based on communal, not individual rights. But otherwise, because we are stuck with this crisis, I would say let's support the amendment, but say that you cannot nullify a customary marriage because you say your marriage is registered, and that should be immaterial. And that I think these difficulties must also make the legislatures force the Department of Justice, and actually the Department of Justice is not a competent department to deal with this question, because the department that deals with traditional leaders is COCTA. Why give this responsibility to the Department of Justice, which is focuses on individual rights, which are Western systems? So I think we need a review of a system, and I think COCTA should be seized with these matters. And also we should make sure that civil marriages do not take precedence over customary marriage, because marriage is not about a signature. Marriage is about an agreement between the two parties, including the two families, including the ancestors of the two families. And if you disadvantage women, you are also disadvantaging children. And the notion of an illegitimate children should not exist in our vocabulary, because what makes a human being born of two persons, illegitimate and another one legitimate, is just utter nonsense, wrong jurisprudence that we are entertaining. Thank you.
Thank you very much, Mr. Mutega, Prof. Those who are joining us, I see there's a whole lot of people that are now joining in the discussion. We, as the Gauteng Provincial Legislature, we are conducting public hearings on recognition of customary marriages amendment bill. I'm now going to allow inputs by different stakeholders that are here. I see Tobile, your hand is up. I'll start with you, and Commissioner Day will follow. Who else wants to speak? Okay. The two are going to speak. Tobile, you are number one. Say again. Who is me?
I'd like to also make a comment, ma'am.
Okay, and you are?
Nicholas Marx.
Nicholas Marx. Okay. Those who have a facility of raise hand, just raise your hands and I'll note you. I think it's Jingan, you'll follow after Commissioner Day. Okay, Tobilo, you're number one.
Sorry, Chairperson, I also cannot put my hand up, but I would like to speak.
And who's this?
Vusi.
Okay, Vus. Okay, can I note it's going to be Tobile, and then Nicholas. Commissioner Day, I'm going to put you last, and Vusi. Please note your numbers so that I don't come in as and when. I see Busi, and then Busi will be number 4. Commissioner Day, you'll be number 5.
Chairperson.
Thank you very
Chairperson, I've been raising my hand and you didn't recognize me.
Who's this?
Mandla
Sorry,
Pete.
Oh, Mandla Pete. Okay, your function is not. Then you'll be number 6.
Thank you.
In that order, to avoid that I come in, you please note your numbers and just come in after the first speaker is spoken. Tobile?
Thank you.
Thank you, Chairperson. Good evening,
The
everyone.
rest of the hands, I'll come back again. I'll note you solely. Continue talk.
All right. Good evening, everyone. I hope you can hear and see me. I am Tobile Ntsimbini from the University of Limpopo. I am an attorney and a lecturer at the University of Limpopo. Now, I really appreciate this opportunity to give my inputs to this bill. As a person who's lecturing or teaching customary law, it is of great input to me and also to my students, because now I'll be more empowered and I'll be able to give them some of the inputs that I've been learning here today. Now, I'd like to applaud the 2 judgments, which is the Gumede and the Ramohobi judgments, because these judgments, they are really bringing the equality that most disenfranchised or disadvantaged women actually were enduring for the longest time. These women now, they have the right to equality, to own, control, and manage the property, amongst other rights that have been given to them on these 2 judgments. Obviously, this judgment, it brought immediate relief to these vulnerable women who also are enjoying those rights currently. Although I have seen these 2 developments in terms of the customary law, but also the issue that relates to the definitions of, I guess most speakers have indicated this, the family property, the house property, and the marital property. I believe if these definitions, if these terms are left undefined, they are going to create a lot of problems, because different people will interpret these different terms in terms of how they understand and how they want the terms to suit their particular needs at that moment. So on my submissions, I actually made comments in terms of how to define these particular terms. So that was just my input. So I said in terms of the family property or the marital property, it can be defined as one, because when I was checking, I actually didn't see much of a differentiation between the two terms, which I said this property could be the property that is contained in these houses, that is constituted by these marriages of these different wives in polygamous customary marriages. And I termed the house property to mean the property by the husband and the wife of the houses concerned. That is just my contribution in terms of those terms. Although I note these contributions by these courts, but there's a persisting challenge that exists in the recognition of customary marriages. Now, during the various community engagements that I've been involved in, there are some concerns with the failure to register customary marriages. Most speakers have mentioned the registration of customary marriages. Now, this concern is borne by the fact that parties, more especially a man and a woman in these customary marriages, these parties will conclude a valid customary marriage in terms of Section 3 of the Recognition of Customary Marriages Act. Sorry. Now, this marriage, more often than not, will not be registered because as per the Recognition of Customary Marriages Act, non-registration does not invalidate this particular marriage. Although in Section 3, it is encouraged that this marriage must be registered. So more often than not, this marriage will not be registered. And you find that after concluding this customary marriage between these two parties, this man and this woman, these two will now enter into a civil marriage in terms of the Marriage Act. Now they will enter, mind you, we know that if you enter into a customary marriage, that marriage will automatically be in community of property unless the parties have signed an antenuptial contract. Now, in most cases that we come across, these two parties will not have signed an antenuptial contract, which automatically means this marriage now is in community of property. Now, when they go further and enter into a civil marriage, they will enter into a civil marriage with an antenuptial contract. Mind you, this customary marriage still exists, which is in community of property. Now, these two parties have entered into a civil marriage, which is now regulated by an antenuptial contract, which regulates their matrimonial property systems. Now, this means that these two parties have now changed not only their marriage system, which was a customary marriage, but they've also changed their marriage regime, which is now regulated by the antenuptial contract, which is in place. And more often than not, this antenuptial contract will be which excludes the accrual system. So it is worth noting that the conclusion of this antenuptial contract is generally initiated by men, generally being the operative word here. It's generally initiated by men. Now they give the excuse to their wives to say, no, we want to protect the businesses, we want to protect the family, pardon me, should the businesses be unsuccessful. Now, these women, they obviously trust their husbands and they will conclude this antenuptial contract when they enter into their civil marriages. Because more often than not, generally men who conclude customary marriages, they do not want or they are not keen in registering their customary marriages. Therefore, when they go to enter now into a civil marriage, when they go to the Department of Home Affairs to conclude the civil marriage, there is no existence of or any indication of the existence of a customary marriage which is in community of property within the Home Affairs. So now this civil marriage, which will be out of community of property without the cooperation of the accrual, is then registered with the Department of Home Affairs. Now, it cannot be disputed that these women who enter into these civil marriages with the operation of the antenuptial contract will now be disadvantaged because they are not going to have the right to own, control, and manage the assets that are going to be of this marriage. Now, also, it now brings a problem because the equal status that is put in place by the Recognition of Customary Marriages Act in terms of the ownership and control and management is not enjoyed by these women, and their equality and their human dignity in terms of the Constitution is now infringed. Now, also a problem that persists is a problem where the registering officer within the Department of Home Affairs, he or she or they are given a discretion in terms of registering these customary marriages. Now you find a problem where, because in terms of Section 4.2 of the Recognition of Customary Marriages Act, it states that any party, it says either spouse may apply for the registration of the customary marriage. So now if a husband is not keen to go and register this particular customary marriage, the wife might go and say, okay, I want to go and register this customary marriage. But when she arrives at the Department of Home Affairs to register this particular marriage, you find that the registering officer refuses to register this marriage because they say in terms of the Recognition of Customary Marriages Act, both parties must be present. So you see, there is a disconnect between the specific words which states either spouse and what the registering officer states and says both parties must be present. So these women, they find themselves now in a position where they don't know what to do because they are turned back and said, no, both spouses must be there. And when they go back home, this man is now refusing or is not willing to go and register this customary marriage. And more often than not, these women, they find themselves in destitute because more often than not, they don't have money to go and seek legal advice or legal representation to take these matters to court. So they are left in a position where, number one, there is a recognition, there is a customary marriage which exists, which was just put in abeyance, for lack of a better word. It was put in abeyance and then a civil marriage was entered into. So there is a serious disconnect between these two, and this problem, if it's not addressed or if it's not specifically addressed in terms of the bill, which is not there currently, it's going to still persist, because even though the department and the minister are forever publishing gazettes to say, we note that marriages which were not registered, parties must come forward, we are extending, and now the time is extended to 2024 to register this kind of marriages. But because these women, they are not well informed of maybe the registration, or when they go to register this kind of marriages, they are turned back and say, no, we want both spouses to be there to register this kind of a marriage. So this is a problem which is still persisting, and it's a problem. So now the recommendation would be that probably the Department of Home Affairs must conduct robust campaigns, especially in rural areas, robust campaigns in terms of registration and alerting women and men of the importance of registration of customary marriages, so that they can be proof within the system of the Department of Home Affairs that a customary marriage exists, because now we are making customary marriages to be inferior
Thank you very
than
much.
civil
Point
marriages.
made,
All right.
Ostobile.
All right, thank you so much.
Thank you. Let's not follow the example of Mem Tobile. Try to save time. I'm told data is very expensive. Our second speaker was Busi. So note your numbers. Is Busi, Nicholas, Vusi, Mandla, Soli, Dingan, and Bentau.
Did you say Busi or Vusi?
No, I'm confused.
Commissioner, you are going to be the last one to speak. Let's allow.
Okay, so
yeah, there's another. There's a Busi Siabe, Busi Siwe Siabe, and there's Busi Siwe Day, which is yourself, Commissioner. So there's also Vusi. So Busi comes before Vusi. Sorry. Excuse my tonalizing Zulu. In that order.
So is it Vusi now? Sorry,
It's
Chairperson.
Busi, sorry, Busi.
Okay.
Okay, let me use Siabe. It's Siabe now.
Thank you very much, Chairperson. I hope you can see me. My network, the touch and go situation on my side. Firstly, I think that the bill is a very important piece of legislation that needs to be passed expediently and as soon as possible. I'm just curious about certain aspects of the bill, especially when it comes to the property element. So I'm curious about whether, academic certificates obtained while in marriage belong to both the husband and the wife. And I ask this because in a divorce case between Teswa and his ex-wife, Ellen, the two married around 1995, and in 2012, Teswa was a breadwinner for the family, and he was first a primary school teacher, and then a secondary school teacher, and then became a lecturer at a college. And the woman, essentially, Ellen, contributed to household chores and businesses. After he completed his tertiary education, Teswa divorced his wife and the woman demanded the High Court to rule that there is property in the education qualifications of the man and that the qualifications are family property. So what I'm trying to basically ascertain, and I'm hoping that this bill will make clear, is whether are earnings arising from acquisition of qualifications or licenses a marital property? Does a spouse who loses benefits from such qualifications through divorce, or should they be compensated for the loss of distribution of matrimonial property and other matrimonial orders made by the court, while also considering the other spouse's earnings? I think when we have a clear understanding of what constitutes marital property and family property, we will be able to deal with such situations and such instances, because most of the time in the current economic climate of our country, you have a situation where in a household, more than one person has to go and acquire an additional qualification in order to bring back and sustain the family. And once they do that, then they divorce themselves from the family, and there is no retribution that other family members can get. So in a situation where a husband pays for one of his wives to go and get a qualification and she becomes an engineer, do the rest of the wives, does the husband have, to a large extent, some sort of acquisition towards or belonging towards the academic qualification? I think we should take into cognizance that the beauty of our Constitution is that it provides for the recognition of the rights, for the rights that we were previously denied. One of these rights is the right of women married under customary law. And more often, these women would be at the receiving end of a of the brutality of the system of patriarchy, and would often be left destitute when their customary husband died without leaving a valid will. Do we also have instances or clarification on what happens when a marriage crosses borders? And what I mean by that, if a man comes from, let's just say, Malawi and marries a South African woman, and he's got another wife in Malawi and he passes away after acquiring citizenship in South Africa, how then do we handle those kinds of situations? Are they left up to the courts? I think the bill needs to be very specific, because if we're not specific on what could possibly happen and look at all the various angles that could arise within customary marriage or the dissolution of a customary marriage, then we might find ourselves in a situation where the law contradicts itself and verdicts that are given by various courts are contradictory. So I think we need to be very specific on how we amend this bill and the amendments that we put in the bill. And these amendments need to correct, the deficit of, what we were brutally denied during the apartheid era. And again, we must be ashamed that we correct this deficit after being instructed to do so by the courts. This was something that should have been done, as we moved into the new democratic dispensation, but unfortunately, it is not something that has happened. I think we must also, however, bemoan the delays in correcting this declaration of invalidity, right? The Constitutional Court confirmed the findings of the Limpopo High Court in November 2017. The Parliament was given until 30 November 2019 to correct this deficit. And we are passing this bill only later on, and there needs to be a way to recoup time for people who were married between 1994 and 1998, or between 1994 and present day today, because I think we don't cover what happens to people who were in customary marriages who were married before 1998. I think that also might become a problem, because those marriages might also come to dissolution. We might need to address them, and we don't want to have a situation where there's a contradiction within our court systems, because obviously we have to be able to set a precedence that will be able to work for everyone, regardless of religion, faith, and ethnicity as well. This bill needs to encompass what we like saying is, the rainbow nation. So we need to be able to find the rainbow nation elements to this motion. And I think the EFF actually presents a very good debate when in Parliament, when they speak about the amendment of this bill and when they make their contributions to the Customary Marriages Bill. And I think a lot of the suggestions that the EFF presents in Parliament are suggestions that would work well in the construction, the consolidation of this bill. And I hope that the House will take them into consideration. Thank you.
Nicholas? Thank you very much, Nicholas? Is that Nicholas? Ngicela ucishe i-mic yakho sisi, please. Okay, Vusi, come in.
Thank you, Chairperson. I'm sorry I cannot switch on video. My battery on my mobile phone is about to die. I've just been instructed to switch off video, so I can't see anyone. So I'm sorry, Chairperson. You won't be able to see my face. The point that I would like to make, first of all, let me deal with the introduction. My name is Vosingo Gomashe. I'm from a civil society organization called Land Rosa, which is short for the Land Rights Organization of South Africa. So this bill is really very important for us, as we have been really troubled by the fact that land rights for women in rural areas, especially in polygamous marriages, is really affected. So we are happy with the amendment, but the issues that really are sort of troublesome is the issue of the definition, of the different types of property that has been listed there in Section 7, marital property, the family property, personal property, etc. I think it is problematic, the fact that these are not being defined. It's only saying that according to the customary law. So that kind of makes this amendment ineffective in a way, because first of all, there is an omission of this word according to customary law. And then when it comes to definition, it then says that definition will be according to customary law, bringing what was omitted back. So that makes it totally ineffective. So there should be a definition. It shouldn't just be left like that. I've noted that Tobile has, in her comment, attempted to give the definition. It's a good thing. That's what the discussion is supposed to be all about. What is the definition? Secondly, it is the principle of equality that also needs to be looked at. If they say, for instance, the second wife is marrying this man after the first wife has been in the marriage, for instance, for about 5 years and has accumulated property. And then you're coming in to say that, we now share equal. So that there needs to be the definition of marital property needs to be gradual. Every time the man adds another wife, there needs to be a definition, a redetermination of marital property, so that that wife can share 50-50 with the husband on what the husband has, taking into account that if you've got a first wife, that wife has got 50%, you've got 50%. Your second wife gets 25%, you get 25% of the entire family wealth that you have, and so on and so on. By the time you get to the seventh wife, you're actually getting poorer and poorer. You would actually have 0.125% or around there. That you would actually having to be sharing. You know what I mean? You're not coming in as the seventh wife to share equally with the wife who has been in this marriage for 15 years, for instance, and having accumulated wealth as well. And lastly, although perhaps not connected to what is being discussed here, is the fact that an act that was repealed, Clara, actually left a void. There is nothing that came up to replace Clara. So as to say that how will the communal land be administered? Because in actual fact, it should not only be houses. It's not houses in the rural villages. It is actually homesteads. Every time you add a wife, that wife is actually supposed to have her own homestead. It's not just a house. It's a kraal as well. It is animals, that you have accumulated and so on and so on. So an act or something that would come into the place of Clara would actually assist us in as far as that is concerned. Thank you, Chairperson.
Thank you very much, Ntate Vusi, for those interesting inputs. Our next speaker is Mandla.
Thank you so much, Chairperson. Can you hear me?
Yes, Mandla.
Okay, I'm also trying to switch on my camera. Do you see me on camera?
We saw you. You are in darkness, but it's fine. Continue.
Okay. Honorable Chairperson, a lot of speakers have actually expressed my views. However, the point that I wanted to mention here is that in terms of family property and in terms of marital property, how do you make a difference? I'll just make an example. A man owns 100 taxis in the taxi industry, and he has 7 wives. And all these wives are married under customary marriage. So when the man passes on, normally you'd find that the brothers and the clan and whoever would actually make it a point that those women get nothing. They'll come around and say, you were sitting at home, we helped this gentleman to accumulate all these things. So my worry is that I find it that women are not protected when it comes to things like that. Now, I feel that somehow, like Professor Mutsa has spoken about the African jurisprudence, I think this is something else. This is something that really must be pushed so that women are also able to get assets that they have actually helped these men to accumulate. Today, we're complaining about street kids. You find that those kids are being kicked out of their homes by men who did not work about this. So the question that I actually wanted to put across is that how do we make sure that the women are protected and the women are able to get the assets that belongs to the husband? And secondly, how do you protect the children to make sure that when the husband passes on, all these assets, the estates and everything else is actually given to the beneficiary of the husband? I thank you with that short speech of mine. Thank you so much, Chairperson.
Thank you very much, Date Mandla. For those who are joining us in different social media platforms, we are making inputs on recognition of customary marriages amendment bill. If you check our website as Gauteng Provincial Legislature, there's an email address where you can make your written submissions. The next speaker will be Dingan, and followed by Solima Kola, then Bentau.
Thank you, Chairperson. Thank you for giving us this opportunity to be part of this magnificent topic. And thank you once more to all the organizers, not forgetting, of course, my MPL, Dalton Adams, who made sure that we also become part of this program. Thank you once more, and thank you for giving us this opportunity as well to speak to the honorable members that are responsible for this portfolio committee. I don't have much to say, but except the following: that the ACDP supported this bill for two reasons. One was that wives in polygamous marriage should be treated equally because they were treated unfairly before. Two, ACDP supported this because of it's not because we as ACDP condone polygamists, but it's because of the rule of law. And this bill came into being because the Constitutional Court called it for it. Those was the comment during the speech in this session in Parliament by our honorable member, Steve Swart, in which we thank him for being contributing much into Justice Portfolio Committee. So now, I just want to find out, there is something that Dr. Matole, Professor Motshekga had mentioned, and in which I think it's very much fundamental, in which if in this bill can be considered, I think this can work more for our indigenous people or Black people, for so saying, in which I don't subscribe to one as a Black person, but I subscribe myself as a South African and African. So Professor Motshekga said that the challenge that we are facing, it's because government has contributed to those challenges that we are facing today by removing the traditional courts and then and others traditional justice people that were involved on making sure that even our people are protected ngisho nasemakhaya where they are living. So what I wanted to ask the members of this portfolio committee is that, will be that possible that in this bill should be considered the reinstating of the traditional courts, if it's possible? That is my appeal. Thank you very much.
Thank you very much, Jingan. Soli?
Thank you, Honorable Chair.
and the other participating members. My name is Suli Makula. I'm the practicing attorney in both Johannesburg and Polokwane. Chair, I've already made a written submission which was emailed to your office. I just want to congratulate you and other portfolio members for making it a point that the ruling of the Constitutional Court are being adhered to. I have already indicated in my writing, Honorable Chair, that the amendment does not only give effect to the court orders, but they also give effect to the supremacy of the Constitution and the rule of law. Chair, we also appreciate that the Constitution of the Republic of South Africa reigns supreme, meaning that any law or conduct repugnant with it is invalid. And then that is why the Constitutional Court has made a ruling in the manner in which it ruled. And then that is why also your office saw it necessary that the amendment must be carried away. Honorable Chair, in my writing, I've made an input on the preamble of the Constitution, which reads thus: that we, the people of South Africa, recognize the injustice of the past. We therefore, through our freely elected representative, adopt this Constitution as the supreme law of the Republic, so as to heal the division of the past and establish a society based on democratic values, social justice, and fundamental human rights. So it is against this background, Honorable Chair, that I personally support the initiative that your portfolio committee has taken in ensuring that the court orders, as well as the constitutional compliance of all legislations in South Africa, particularly the recognition of Customary Marriages Act, are taken into cognizance. Chair, lastly, there was a question about asked by Soli. I just forgot his name. He asked a question about what happens in a situation where the gentleman marries in the rural home and lives into the city, and then there conclude a civil marriage. And then he wanted to check what is the law in that regard. There is a number of case law, Honorable Chair. There's the case of Ontlako versus Mahlangu. The marriage which was concluded later in terms of civil rights is null and void. The fact that it's registered in civil rights does not necessarily nullify the marriage in terms of the customary rights. So if you marry later in terms of civil rights, that does not nullify the marriage in terms of the customary law, but the marriage that which was concluded later in terms of civil rights, that is the one that becomes null and void. So therefore, that marriage will not succeed. He also asked a question about what happens to the assets of the deceased, or what happens to the property of the joint estate. If he marries first and later marries the second wife, will the second wife be entitled to 50% share of the assets of the joint estate? You see, Honorable Chair, the reason why the Act says the husbands who want to conclude more than one marriages must first obtain consent from the first wife is to guard against that, so that the first wife can have an opportunity to protect her own rights insofar as the properties are concerned. Then they will therefore ultimately enter into agreement which will then safeguard the assets of the first wife and then vis-a-vis that of the second wife. He also put a thought that there has to be equitable share. He is correct in that sense, because now once the first wife has given consent, he would give a consent and thereafter safeguard what she believes is her properties or her share in terms of the marriage in community of property insofar as customary marriages are concerned. And then thereafter, the second wife will then take it from there where she came into marriage in terms of marriage rights. Honorable Chair, that's our proposed there. That is the contribution that I can make, and thank you very much.
Ntate Ben Tau.
Thank you. Just want to switch on my camera. I don't know if I'll be able, you can be able to see. Okay. Mine is simple. I'm going to just ask a question and maybe make an input there. My name is Ben Dao. I'm from a civil society called I Am a Solution. So, and would like to thank the legislature for inviting us to be part of this. So my question is going to be simple. We have, in terms of this inheritance, when a husband had married 2 wives, I'm just going to make a scenario now here. My previous speaker almost touched on it, but it didn't come through to it. In this sense, a husband gets married in the rurals and comes to Joburg or go to a working place where he doesn't see his wife forever, for a long time, and after that he gets into a civil marriage. So what happens when they get into a civil marriage, or he marries her another woman, and in that sense he doesn't get a consent from the first wife, because like I said, the previous speaker spoke about that, the consent that he has to get from the first wife. So if he doesn't get the consent from the first wife, what way, if it happens that the speaker passes by, the husband passes on, so what's going to happen with the inheritance that the husband has? Because we understand that the second wife to be married, the first wife has to give consent for a second wife so that she also can be part of the inheritance. That's the question that I have. Secondly, I think again, just to make an input, I think again we've lost a way that we need to make sure that our traditions are upheld too, because I think at the end of the day, as the speakers have said, we took more of the Eurocentric way of marriage, and we forgot mostly of our cultural marriages. So I think the traditional codes, they need to be brought back so that we can be able to solve the issues within, because this customary marriage, most of the time, they are mostly on the traditional part. They are handled by tradition in a traditional way. So I think if we can have a traditional code that will have to deal with this, as our previous speaker said, most of these our lawyers, they deal with it looking it in a Eurocentrical way, not in a traditional way. So if we can bring back the traditional codes, I think we can be able to assist in this matter of inheritance and property sharing. Thank you, Speaker.
That was our last stakeholder. I'm now going to hand over to panelists to make responses where they feel they need to respond. But remember, this is an input, a public input making platforms, so that we make inputs as Gauteng to the National Parliament. So we are also still inviting inputs and written submissions from individuals in Gauteng who wants to make their voices heard on this bill. I'm going to check Lulama and Shiman whether you want to take a bite. Commissioner Busi?
Hello, I am here. I'm going to switch on my camera. I do think that the issues that have been coming through is a recognition, even subconsciously, of the difficult terrain that the legislation is attempting to regulate. It is regulating and is attempting to intervene in a process of dispossession and marginalization of Black women that is 400 years old. The responses legally are not going to be perfect. And definitely in relation to the amendment that we are discussing right now, which is Section 7, central to how we understand how this, amendment should continue is that, does it center the right to equality of parties to determine what happens to the matrimonial property? And the simple answer is, in terms of the cases that have been put forward by the Constitutional Court and the decisions that have been put forward by the Constitutional Court, this is what the section is doing. However, we do need to point out that the system of regulating customary marriages is still based on a patriarchal understanding of who contributes to property. So how do we understand who contributes to the matrimonial property, but also who is entitled to the matrimonial property upon the dissolution of marriage? Whether that dissolution happens through death, as many speakers have mentioned, or through divorce. But what we are recognizing is happening through this legislative amendment is that the courts and the legislature is ensuring that women, or rather, let me rephrase it, that the termination of marriage is not the weakest point and does not expose Black rural women to additional vulnerabilities. And I think that as much as the questions and the thoughts and the inputs have been important, I think that they miss really the key contribution that we are currently having to engage with on this platform. Does the amendment of Section 7 further and contribute to the equal recognition of Black women? The answer is unequivocally yes. Is the recognition of marriage, of Customary Marriages Act, does it require further amendments and further interventions? Definitely. But I think that we cannot conflate the two currently. We can accept that Section 7 is rectifying a very small portion of this. And as our submission, as the Commission for Gender Equality does state, we have noted as the Commission additional amendments that need to be made in relation to the Recognition of Customary Marriages Act, particularly the clause on recognition of marriages, which still allows men to exercise almost a de facto veto role. So if a man is not there to say, yes, I agree to the registration of this marriage, a lot of times what happens is that the Department of Home Affairs does not register that marriage, and that continues and perpetuates the patriarchally enforced inequality of Black rural women. It is very important we understand who are the vulnerable groups that are being protected here. It's not your urban woman who is married through civil marriage. It is your rural woman who probably has a primary school marriage, who probably doesn't understand fully her legal rights. So it is important that this section goes through at this level and is passed through at the National Assembly and is ratified by the President. And that is our submission as the Commission. And we do hope that the Gauteng legislature does reach out to the Commission for Gender Equality, because we are here to advise at the provincial level, to say to you and to give you the necessary information in order to make these decisions, in order for you to understand the historical processes that we are trying to rectify. This is a colonial this is amending colonial history. This is amending apartheid history. This is amending gender discrimination. This is amending collectively the traditions of Black Indigenous communities. I won't go into who is defined as Black. I think that across the board, if a marriage fits within the boundaries of what a customary marriage should be, I think that this legislation should apply. I thank you very much for making me part of this space, and I thank you for your patience with me trying to log in continuously. But I do hope earnestly that the participants do reach out to the Commission for Gender Equality, because this is what we're here for. I'm particularly passionate about this particular aspect. One of the speakers did speak about the links between customary marriage, matrimonial property law, and the land tenure matrimonial regimes. I am also involved in that as part of the commission, and we've made submissions on the amendment of Section 25 of the Constitution, and I'm more than willing to share that information in order to have a cross-societal dialogue. It is important, and what we represent are minority groups, vulnerable groups, and we are a Chapter 9 institution. We have to remind people that we are at the level of the public protector. We are institutionally, we should be institutionally independent. We do ensure that even internally we fight to ensure that we are institutionally independent. So you can trust us to ensure that your ideas and thoughts about gender equality are taken into consideration. Thank you very much for the platform, and I hope that we will share our document with you through our acting.
Thank you. Thank you, Commissioner. Thank you very much. Mokhadi, you want to have a last bite? Mokhadi, Nakana? Advocate Sima? Oh, they are gone.
I'm
Shiman,
here.
yeah, thank you. Do you want to have a last bite?
Yeah.
Yes.
Sima, come in, and Shiman, you'll be the last before Prof.
Thank you, Chair. I'm not clear who is supposed to make submissions, but I just thought one last point that I just wanted to note, which Commissioner Day has also raised, is that the issue of defining what is meant by marital property, house property, family property, and personal property in the proposed section must be looked at, because it is our experience that the very reason for contestation, disputes, and litigation within families relate directly to assets accumulated by the parties during the marriage. And we can't emphasize that these need to be clarified. In addition to that, there is a concern that patriarchal stereotype will feed into the manner in how we interpret marital property and all other as defined in and practiced within custom. So this is a very, very unique opportunity to establish and define these terms. And we have raised concerns with the Department of Justice during the public participation process that defining the terms may alter or change the custom. And we need to be able to look at that. We'd also suggest that there is no need for litigation if these issues are particularly raised. And a second issue that we want to emphasize is that in both the Kumedi and the Mailani judgment, the court actually ordered that the departments must ensure that the judgment is implemented by its empowerment programs. And it's very, very important that the Gauteng legislature look at and ensure that there's oversight in relation to the programs which deals with the empowerment, because we know there are major challenges within the court system in terms of implementation. So thank you very much for having the Women's Legal Center. And we are also will make our submissions available if necessary, so that you can make an informed decision whilst looking at the bill. Thank you very much.
Thank you very much.
Chairperson. I have to run to another meeting. Can I just, I will be very brief. Chairperson, I think this process must be seen as part of the transformation agenda that government is expected to drive. So the decolonization of the language is very important, because English law came from traditional courts. Roman Dutch law came from traditional courts. Why do we continue on an African continent, continue to say customary law? In other words, we are ranking our indigenous African law lower than this other. So that terminology has to change. And also the reinstatement of traditional courts must be linked to this transformation of the so-called customary law, because there are different hierarchies of these courts, and these hierarchies must be exhausted before these matters are taken to Western orientated courts, which are staffed by people who have not studied African law, who are not interested in African law, who are using Eurocentric paradigms to deal with African issues. Because if we want to restore the dignity of African people, we must start by recognizing African values and make sure that we seek African solutions to African problems. We can't continue to be junior second-hand players in our own continent and country. And please, let's not talk about black customary law. We are not blacks, we are Africans. Black is a political term, it's a generic term referring to Indian, colors, Chinese, and others. We are Africans. Thank you very much.
Thank you, Dr. Mutsecha. Thank you for mentioning that.
Re a leboga Ramotshega re solofela gore le tla phela le le teng go tla gore tlhatlha ka nako tsotlhe. You are now released that re a leboga. Thank you very much. Advocate Sima.
Thank you, Chair.
Is Sima or Sima?
And thank Sima.
Oh,
thank you.
Okay.
Thank you, Chair. In closing, I wish to thank you and your committee for the invitation. I have already submitted my written submissions to your office, which I hope you will receive in due course. But what is important in closing, Chair, and your honorable members, is that it is important that African people and African women in particular are protected by the laws of this country. The laws are made for the people, about the people. So it is important that as the committee is sitting to consider all the submissions, it is important for the legislature to have in mind that our own people are the ones who have suffered, African people in particular have suffered the most due to the injustice of the past. It is now their turn to benefit and for this injustice to be redressed. So it is for this parliament of the people, by the people, that we hope that it will pass the laws that are pro-poor and pro-African in nature and character. Thank you, Chair.
Ralem Khantate, is Mokhadi back? Mokhadi Nakana? Okay. Thank you very much to everyone who took time to participate in this, whether in this platform or other platforms that we are streaming on. This is a public participation process, and the process is opened in Gauteng until the 30th of September. So we request that you help us spread the word. And I think lawmaking is the only tool that we have to can transform our society and our country. So we urge all of us here to really take the opportunity to make input so that we build a South Africa of our dreams. I'm now going to hand over to Member Ngube, Busisiwe Ngube, who's going to, on behalf of the Portfolio Committee, do vote of thanks. To all those who have participated in this process, please spread the word that the process for public input is open on the bill, and they should check our websites for more information. Member Ncube? There's a load shedding problem in
Honorable Chairperson. At this time of the hour, you see the COVID is making us to work 24 hours. Thank you very much for all the stakeholders that have participated in these discussions. You have really empowered and educated us. I've got many things that I have learned today. So, as the chairperson has already said, that of the public sessions that we need to do, I had some cut by the chairperson to say time. Indeed, then what you need to do, all those that still need to put their facts on paper, not even on paper, because now we are using this kind of the gadgets. So hoping that you have our emails where you would have to send your inputs so that your inputs matter. All these inputs will become part of us, and we will have to, during our now we're left with 4 years, our 4 years push these things, but also the public must also advocate this. Today, Honorable Chairperson, we've heard from the learned. I think also the person is going to Maibai and wherever, if possible, because that's where, and hostels where you have these kinds of marriages where at the end you would be surprised why you are not inheriting. But also with the youth also are falling into these kinds of marriages, not knowing that your marriage has been registered or not. And you'll find that that man, because of the age gap of a 21-year-old with a 60 or 70, you find that your marriage doesn't work at the end when you are supposed to be inheriting something. So it's still a long way to do, but I think it stretches up to the 2027. Honourable Chairperson? Okay, so thank you very much for your time.
28.
And the contribution. We are waiting for your written responses. Even the XOP and the NA and the department, in terms of only responding to the verdict of the court, but deal with this cultural and traditional aspects that we still have to do. Thank you very much.
And good night to everyone. And thank you very much, honorable members of the Gauteng Provincial Legislature. We thank you all, our stakeholders and our wonderful panelists. Thank you very much. Good night. Sintana Nonke Makai.
Thank you, Chair. And good night.
Thank you very much, Chairperson. Good night, everybody.
Good night, everyone. Thank you.
Good night.
Thanks very much, Chair, and good night to everybody.
Bye-bye.
Thank you. Thank you, Member Adams. Bye. Good night. Good night, everyone.
Bye. Good night.